and I'm surrounded by cops every day. So that's where you, and I understand we have a range of things just like the public does. But the fact is that being tough on crime and supporting this measure.
But in the end, is there ever a day you don't think about public safety?
Absolutely not. That's my responsibility. That's my responsibility.
Chairman Serper, while I was U.S. Attorney, and while I served on the AJC committee, I noticed budgets of the U.S. Attorney's Office falling. I noticed BOP, the Bureau of Prisons budget rising. Some might say there's, that's natural, but it's not something for concern. I also noticed, however, that we started to have hiring freezes. We also withdrew from our participation in local task forces, and it seemed as though our U.S. Attorney's Office no longer remain a member of the community. How does reform affect budget, and should that be a proper place for emphasis?
Absolutely. This particular debate gives us the opportunity to look at incarceration from a point of view of social justice. What is the right thing to do for people? And then what is the cost? I will share with you briefly that Governor Gary Block hired me, Mayor Bill Purcell hired me, Mayor Mitch Landry hired me, and not a single one of them told me the government was broke when they hired me. But the government doesn't have the resources and funds that it had or should not have had. But at the end of the day, if we're spending tens of billions of dollars on incarceration, and we know from a professorial academic point of view that incarceration is the most expensive and least effective way to change behavior, why wouldn't we want to take advantage of that and make sure we have enough U.S. attorneys practicing in the 95th district? Why wouldn't we want to make sure that state police gets the funding and service they need, and local agencies get the funding and service they need to serve the very needs of the people that are oftentimes, and Chief Agnew just said it himself, I was police chief for 3 different states. Communities want the police to be in partnership with them, and when these mandatory arrests occur with people with mental health issues and drug alcohol issues, it starts to separate us from communities, and that's never a good thing.
Judge Mukasey, I know the thought that you've put into endorsing this bill. I know that you previously indicated that you not wanted to see reform go too far, and which is an appropriate balance or an attempt at balance. I know you have expressed some concerns. I noted that that recently a couple of vocal critics, and I quote, stated that this bill would make all drug traffickers eligible for reduced sentences. Is that accurate, and why? What has your influence been in hopefully shaping this bill to not result in something like that?
I think where that's misleading is something that I mentioned in my opening remarks, which has to do with, if I understand the services correctly, which has to do with people who are in long periods of time on drug abuse, who become eligible because of the lower mandatory minimums applying retroactively. To say that somebody is eligible is one thing. To say that they're going to be released is something else. And again, this goes back in each case to district judge who imposed a sentence, to the prosecutor who brought the case. And one of the things they're going to have to determine, for example, is whether, if the sentence, say the case ended in a plea, whether the negotiated plea provided for the level of incarceration that was thought to be necessary to protect the people. If that's the case, then that person isn't going to be released, notwithstanding that the mandatory minimums have been lower. On the other hand, if it was a plea or if it was a conviction, and the sentence was imposed with less consideration for what was particularly necessary in that person's case, then there's every reason to reconsider the sentence and to permit an earlier release if that's mandated. But one of the things that I found most appealing about this legislation is less the question of the length of the mandatory minimums and their applicability than it is the program within prison to come up with criteria to anticipate the degree to which people are likely to sedate or unlikely to sedate, and try to develop a discipline system to predicting that so that we can figure out who can release safely. And I think that part of the legislation is very difficult.
Yeah, I think that's insightful. I also appreciated your earlier in the hearing in which we both appeared. I think you were precise when you indicated that the 5 and 10 year mandatory minimum is really the bread and butter of the federal prosecutor, and this bill does not affect those. And I know that there may be some that wanted to see more or greater reform in that particular area, but as a in the trenches prosecutor, I know that we were much more nervous with losing the bread and butter tools that we had, and perhaps we avoid the risk that you speak of, and that Rick, you have spoken of as well. I will ask just briefly, and Rick, I know that you have the ability to speak on many of these subjects, but I think you touched on it. There really is a misnomer about who's in federal prison. When I started prosecuting, my daughter, who's now in college, thought that I would be prosecuting out of home every day, and I was a federal prosecutor. You really learn that that's not the case. And as a prosecutor, you probably saw that there were differences, and that a one-size-fits-all does not really work. And you want to expound on that issue?
Well, that's exactly right. The range of federal crimes is so great that as the United States Supreme Authority over mislabeled food or misappropriating jumper cables from a government vehicle, all the way up to public corruption charges and major drug trafficking.
And many of those do serve time.
Almost all of them. Curiously enough. So, yes, it's the idea that the federal prisons are filled with violent and dangerous offenders is misnomer at this point. I think 70% of the federal prison population is actual violent offenders. And certainly in Brett's jurisdiction of mine saw a lot of these white supremacist tax protesters, they're categorized as violent offenders, but even that is different than murderers and rapists and the type of violent offenders that you see in state prisons. So it's that is a major problem, is the one-size-fits-all mentality. And nobody wants to take away the prosecutor's tools to effectively economically resolve these cases. But the idea that any of these reforms being proposed are so extreme that the prison needs to reform is just not true.
Thank you. And lastly, I'll make the point that my support of this bill really grew as I started to see the thoughtfulness of the front end changes. I've supported the back end changes, and I feel like Judge Casey that it is a critical piece to assess in a dynamic way, according to Ezra Tessa, a dynamic way risk of recidivism, and then allow for education, training, jobs for their release into halfway house or home confinement if they have displayed a low risk of recidivism. That's one area of the bill that has not been criticized, but I will tell you why I support the front end changes. Because it really, they have been directed at fixing many malfunctions in the code that we saw as prosecutors. The ability to staff inappropriately the 924Cs, or the inconsistent application of 841. And so you see, I hope, that those that will look closely at this bill, that our fears are not accurate, but our substance has been thoughtful. And that this bill, while there may not be perfection in it, and there may be some fine-tuning or adjustments, this bill should pass. And the Republicans and the Democrats in the Senate should get behind this bill. Law enforcement is asking you to do so. With that, I'd be happy to have questions, and I'd ask that you direct your questions specifically. If it's for the panel, please indicate for the panel. Happy to field. I know the media's in the back, and they're a little tough to see, but we'll get to you. If you want to stand up, that might be easier for us to hear.
Usually you make the microphone. Sharon does that when I said I'm moderate. I've been to a lot of these forums, and you're like the least diverse panel I've ever listened to. Yet you are doing more for the Black community than other panels that I've been to. What have you heard heard, have you worked with other groups in reference to diversity? Can you give us an update? Thank you.
Is there a chairman to
You mean diversity to our membership?
Well, as far as the cause.
racial diversity?
As far as her cause for the sexing reform. I was at the Brennan Center in New York City about the sexing reform, and not much has happened. About 2 years ago, right before Eric was on. And I see finally some actions happening. So can you kind of expand on that?
One of the reasons I think that so many of us, more than 165 and 50 states got behind us, and we're from all walks of life, we're from all experiences, we're also very diverse with gender and racial representation of our group. In another part of my life, I'm the chairman of the International Association of Chiefs of Community Policing today, right, 25,000 worldwide members. And we see this whole issue of arrest and the concept of community policing as a tool which should be at least used to. So one of the reasons this type of legislation and then the federal government following the states, several states have already moved towards meaningful conversations, debate, and changes in sentencing reform that gives officers more opportunity to solve and resolve problems and co-produce safety in neighborhoods that don't use the arrest tool, which helps us be closer to every neighborhood of every different ethnic, racial makeup in our community.
Yes.
I have direct my question, Mr. Parker. You referenced the letter from Association of AUSAs voicing opposition to this as a not far removed from being a firebrand AUSA myself. I was trying to think what are they saying, and I'm wondering if you can articulate what some of the objections. I can certainly think what some of them might be, but what some of the objections are.
Well, I think the primary objection that stuck with me was the belief that they were losing the leverage to effective plea bargaining cases. And I think it also, I also remember thinking that maybe they weren't understanding how limited the actual changes that we proposed are with respect to use. That some of the fine-tuning, adjusting some of the issues that were participated at the time when these structures were in place. And it may just be that they have this belief that no one knows their job as well as they know their job, and that before you change anything about it, they were going to be involved. It could be something as simple as that. The plea bargaining part stuff, mostly.
I want to have Judge McCasey, and then I have a brief comment on that question as well.
There's also a certain element of if it ain't broke, don't fix it approach, in which they indicated that yes, crime rates are going down. They're going down because criminals are in jail. That's the last time in the world that you might have been changed the system. And that has a certain logic. At the same time, we're not dealing simply with restraint. There are economic consequences of this. There are social consequences of it. And trying to balance those, takes a lot of effort. Doesn't take a lot of concentration. I have to think that the best indication of the success of the justice system is the crime rate. And we're going to have to keep our eyes on it. If it goes up, then yeah, there have to be some more tuning in the other direction. But it is time to do this for all reasons.
So a couple of concerns that I would express. The association that has weighed in seems to represent the interests of assistant U.S. attorneys. However, I've not seen a list signed by assistant U.S. attorneys. It's significant. The reason is this is an association. It's not a Department of Justice. And I think in my unofficial poll of all my AUSA friends, they have been struck by the thoughtfulness of these changes. And while their specific objections have been that, for example, in the 924C, that it reduced the subsequent or second enhancement, mandatory minimum enhancement from 25 to 15, or for example, on the Armed Career Criminal enhancement mandatory minimum, not the original mandatory minimum, the enhancement mandatory minimum from 15 to 10 years. And I believe those have been objected to in specifics by the organization. What I would point out, especially for 924C, is it was never intended by Congress that you could buy dope 3 days in a row from the same individual and get them on 3 924Cs without having prior conviction on each one. So I'd like to top apples and oranges when we do, and I'm open to have a discussion with all the AUSAs that are lined up behind the National Association of Assistant U.S. Attorneys who are weighing in opposition against this bill. I'd be happy to have a discussion with them on the substance, because I think what you'll find is incredible diversity of opinion, but of interest in fairness and consistency in the administration of justice among those AUSAs. And I have not had an AUSA tell me that the statements that this is going to make all drug traffickers eligible for release, or that we're going to open the floodgates, that they agree that that's accurate. I have heard it from the association. The back. Yes, sir.
My name's Greg Tossi, I'm with Senator Kirk's office. Many of the people in this room attended a briefing earlier today at around noon by the Association of Assistant U.S. Attorneys. The statistics that they gave and the statistics that we're hearing here could not be farther apart. And as a stamper on the Hill, and I say this to lobbyists all the time, nothing is more important than reliable information. Nothing. Everybody here is a stamper. That's what we count on. I do not expect a lobbyist to make the opposition's case. I don't expect you guys to make the case for the opponents. I didn't expect the U.S. attorneys to make the case for you guys, right? But they came in and said that less than 0.5% of the people in the federal courts or in the federal prisons are nonviolent, low-level drug dealers. So, you know, who we would believe, right? We're looking for reliable information. You should take them up on, and what would we would really benefit from a side-by-side, a debate, where you two guys, the guy this morning was formidable. That was a hell of a presentation he gave. And I came away, I was a civil trial attorney, and I said after doing defense, and I said after plaintiff's case, we should be under the desk, hiding, right? It should be overwhelming. And that was pretty powerful stuff this noon. So side by side, let's say it, you know. And this fellow Cook was pretty good, and he had a strong presentation. I'd love to see the two sides.
I'm not sure there's a question in there, but there is a challenge, and I'm certain we'd love to have a discussion and have Judge Casey respond
My question
to you.
is, who should we believe?
Sure, and just on that quick note, an analysis of what the statutes do is appropriate, and that discussion doesn't have to even be a debate. So let's discuss what the statute does and what the changes are. On data, you know, and I know, that you look for data, possibly. We've relied on the Sentencing Commission, we've relied on the administrative offices of the courts. One problem has been DOJ has not been able to keep or maintain or have the funding for the ability to maintain some of the data that is out there. But Judge McPherson?
Obviously, I wasn't present at everything that you were saying, but based on your description, I think that you can believe every word you heard this morning and still favor this legislation for the following reason. I happen to think that the expression low-level, nonviolent drug offender is an oxymoron. Every dealing in drugs is either accompanied by violence or takes place because there's the possibility of violence. And when that person this morning said that less than 0.5% of people present in federal prison are there as nonviolent drug offenders, he was probably telling the truth. Because even the kid who's dealing crack on the corner is able to do it because there's a stash house a block and a half away, guarded by people with submachine guns. And because he has to threat of bringing to bear enormous force and lethal force on anybody who passes through. I get that. But all of that said, people who are there are not necessarily the people who are principally responsible for the existence of the drug dealing ring. And there are people who can be brought around within a shorter period of time than they are defined for. There are also people who can be threatened with a shorter period of time in order to deter them. That's what the legislation is about. I understand that low-level drug dealers can ruin a neighborhood. I'm from New York, where we've had a lot of neighborhoods ruined by street corner drug dealers. But once you get them out, is it enough to say that you're looking at 5 years, when you're telling you're looking at 10 or 15? I have to think it's enough to tell them 5. I'm willing to take the chance that that is true, and then to look back on the people we've put in and consider whether, in their case, their pleas were negotiated with the view that they had to be there for 10 or did they be there for 5? That's all this legislation is doing.
I think that's one important note, and along those lines, in the Weldon Angelos case, take what was said by the association and our argument, and under this bill, Weldon Angelos is going to serve probably 20 to 25 years. Still, not 55 years, but 25. Remember, he had a gun. It wasn't accurate to say that it was on him. He had it on one of the buys, he had it on him. The other was in the car, and on the last buy, it was in the safe at home. But he got all 3. Under this legislation, that's why this is a modest reform on the front end, and why you have law enforcement here saying, we understand the argument that we want to be careful. We understand that it's not broken argument, but we see that there is the need to fix some of these functions without compromising the issues that are being raised with you. And so remember the practical impact of the bill. Other questions? Yes.
Jordan Richardson with Generation Opportunities. My question is for Judge Casey. You mentioned how sentencing is arbitrary. And one of the criticisms of this bill is that one of the last safeguards against violent criminals potentially being let loose in the street is that a judge would review in the case of any retroactive case that would be brought forward. Can you talk about if sentencing is arbitrary, could you speak to the criticism that maybe a judge reviewing it in the retroactive case could be arbitrary as well? And how could there be good safeguards there and maybe strengthening the role of the courts?
I think there's less likely to be arbitrary in the sense of considering matters that have nothing to do with the judge starts in that instance with a sentence already imposed. And so then the question becomes what changed. It is a lot easier to consider in that situation what's changed, which direction it points, whether it points toward mitigation, which is greater severity, than it is to consider the abstract question of how long some of the moments away. Particularly when you've already had experience with them being away for such a period of time, otherwise they would be doing a retroactive setting.
Another thing to think about in the context of both of these questions, many states have already had this political debate. Many states have already had this social justice debate. Many states have already had this financial imperatives debate, and they've already moved forward with recognizing that incarceration in and of itself has to evolve as everything else in the criminal justice system evolves. Perhaps it was a smart idea 30 years ago, and I happened to be a cop then. I was a cop then. We were dealing with the scourge of crack cocaine face to face, not reading about it, face to face. We've come to learn and recognize that there are other alternatives. So in this debate, at some level, many states have already moved further down the road with a more reasonable, rational, modest improvement in prison sentencing than the federal government has. And in this case, our group is hoping that the federal government will continue to exert a leadership role and let this debate play itself out, and then maybe the next states that go down this path can say, well, yeah, we've already talked about all that, and we've already heard both sides of this issue. But between social conservatives, fiscal conservatives, liberals, Democrats, of all walks of life all come to the same place in states already, and at this particular point in time, it means a lot.
Absolutely great point. The states have been the test pilots for all of this and have had more experience in enforcing criminal laws than the federal government has. And we should be acknowledging that. And in fact, this bill was patterned after adjustments and changes in several states.
We've heard a lot today, Patrick and someone that had the Senate Attorney's office. We've heard a lot today about pros and advantages of this bill. What would you say a potential con or something that you wish you would get more out of would be? That's for the whole committee.
Ben, let's go ahead first, Chief.
I think the most important concern that I have with this bill is that it be done wisely. You know, we talk about smart policing, we talk about a lot of things. This needs to be smart sentencing reform. But what I read in this bill is that there are safeguards, and there are things that the process, I believe, will allow this to be smart sentencing reform. I mean, looking at things case by case, not just saying, well, everybody that was convicted of this crime, we'll treat it the same way. We're going to look at these cases individually, because what all my friends on the panel who prosecute cases know is that what you're convicted of, and what you were arrested for, and what you did wrong can be three different things.
Yeah, I mean, just to there is one element that's not covered all of this bill, that is not discussion, and that is the question of mens rea and statutes that do not include any mens rea requirement. I would have loved to have seen that done in this bill. I also understand that it's a very ambitious project, and that you have to be very careful with public safety legislation that you don't cut too broadly. But I would love to see that as part of a comprehensive reform of prosecution in general and sentencing specifically.
Real quick, Tom and I both have been to more community meetings than anybody else in this building. That's what a police chief does. You go to community meetings every night, someplace. And I don't think, from my experience in Washington, Tennessee, or Louisiana, I should be at Waterbury today, I just thought I would throw that out there. I never felt pushback from communities to have reasonable, rational conversations about who should be in jail. In fact, communities very seldom ever push back against that. And I don't think that we should lose sight of the fact that, just as everyone else has said, all people should be held accountable for their behavior, but it's a fool's errand to think that all people should be treated the same for the behavior that they commit.
Other questions? Other questions?
I'm just going with Chairman Bradshaw. And I'm just wondering how you think you're feeling, how you think it's affecting the country, and if you think there's anything that would be.
I'm happy to start. I spent significant time prosecuting Indian country offenses and know that there are specific challenges. I would say, at least in my experience and on the committees, I served on a couple of committees that were dedicated to analyzing, and I visited as many tribal areas across the country as I could. And predominantly, the 5-year mandatory minimum drug sentence and the 10-year mandatory minimum, as well as some of the sexual assault cases, were they were, if there was a federal prosecution, the vast majority of prosecutions. So I don't know that there is an immediate impact in terms of the changes on the drug prosecutions, but I will say that there were often prosecutions involving firearm. And so there is an impact under the 924C provision, and I think it's a fair impact. It will eliminate as many may know, tribal convictions of a tribal case can be challenges. Witnesses are often family members or friends, and so when you have those cases, I had concerns often about the level of punishment that could be exacted. We frequently found that families, there needed to be more sensitivity on the length of sentences because of some of the challenges in the tribal communities of taking limited number of family members that support larger numbers of family and putting them into long periods of incarceration. And so I think the 924C will have the most immediate impact. I think it's possible, however, that the change to the bill that increases the felon in possession sentence from 10 to 15 years, potential for 10 to 15 years, could have an increase. But there you're talking the sentencing guidelines in which the judges can fashion an appropriate, and it's not a mandatory minimum. So I feel more comfortable about that increase. Those are just my initial thoughts. If anyone else on the panel has thoughts for that question. Yes.
I'm Susan Carmelo, the Sheriff of Bexar County, San Antonio, Texas. And certainly, I believe this is the right direction for this legislation and for the nation. But as individuals are released from federal prison, or decisions are made that other alternative treatments will be done in place of incarceration, that then shifts the cost from Bureau of Prisons to now the communities where these individuals come from. What consideration have you taken into account as that funding will shift to states and local jurisdictions?
That question is playing out right in front of our very eyes in California. And when you read through and watch the debate going on in California after Proposition 47, many of the police chiefs and leaders in criminal justice that I know from there are saying the same thing. Social justice requires we also find a way to treat these people. Because the fact that they were in prison and needed treatment doesn't change the minute they walk out of prison. So we have to really carefully consider that. And we also know, and there's probably very little debate anywhere in American social science research, that rehabilitation and successful rehabilitation is always cheaper than incarceration. And that has to be considered. And bodies that legislate these ideas have to consider that a person who's addicted or mentally ill in prison who's going to be released as a social justice question still has the remaining part of that justice question, which is how we keep them healthy so that they're not disrupting life in their community.
It's a great question. I'm glad that we have representatives from Texas here. A major portion of the bill was patterned after some of the developments in Texas. And to really identify what Texas did, I don't think there's anyone in the United States that would accuse Texas of being light on crime. But it has been interesting to see that even with their strong record of law and order or tough on crime stance, they recently closed at least 2 prisons, 4 prisons. And these are closures not as a result of dilapidated buildings or no funding, it's a result of need. And then the savings has been, I know that Senator Cornyn has indicated somewhere around $3 billion in savings. So the federal system in this part of the bill really did try to pattern Texas and a few other states. And I believe the answer is that if you take, an individual incarcerated maybe at roughly $30,000 per year in the federal system down to home confinement at a fraction of that cost, a few $1,000s per year, you do want to see that some of that savings is reinvested, obviously, or perhaps dedicated so that the transition is appropriate. But it has to be on the front end that we allow that sort of transition to the lowest risk of recidivism and not to individuals that we have questions about or that we have a fear that might not be successful. Because otherwise you have then invited that revolving door to continue. So we're still learning. I think we're learning, and we're gonna have to do as Judge Casey says, and we're gonna have to analyze and watch this, and we're gonna have to come back and see what we've learned and adjust. Others that want to comment on that? Other questions? Sheriff?
My name is Jim Winter, I'm the Sheriff of Salt Lake County. You alluded to the fact that many states have been attempting to achieve as one of them we have made rather dramatic alterations over the course of the last 2 years of justice reinvestment. What we have noticed, and I happen to be a strong proponent of this initiative, what we have noticed is anytime you turn dials, you will have significant unintended consequences. Those unintended consequences are oftentimes human beings. I say that with a degree of caution. The gentleman's words back there really rang true to me. I would caution anyone to turn any dial on a nationwide basis without a real opportunity for protections. My question underlying perhaps my statement is this: is there, and I know the federal government is even less nimble than the state of Utah, is there an opportunity to apply this in a pilot situation in which alignment of services is guaranteed? To the Sheriff of Bexar County's point, what we see in Utah is individuals are removed from the state prison system with the expectation that there will be treatment. When there is no treatment, they recidivate, they're back in the county. It's going to prove this initiative a failure if it is not managed appropriately. So I guess my comments are both cautionary and also a question there. Is there any hope of a pilot as opposed to simply turning the dials the entire federal judicial system?
So I think it's a good question. I'm happy to defer to anyone else that may want to. I'll make some initial comments. Congress has a long track record of I think, dealing with that very issue. And as a result, Congress moves slowly. It is not nimble. And Sheriff, I think to your point, the fact that there has not been meaningful criminal reform in the federal system for nearly 2 decades or so is probably a statement to the fact that it changes slowly. So the pilot program really has to be a careful analysis of what the states are doing. And I agree that turning the dials, I think it's because of the fear of turning the dials significantly that you have modest changes in this bill. I think that's the reason why the front end changes are modest, and certainly they don't go as far as many who have been at this longer than I have been requesting reform for a decade plus, and they don't address many issues. They're a modest expansion of the safety valve. It is a reining in of a few narrow statutes. It's not an elimination of a single mandatory minimum, but it is a slight turn of a couple of mandatory minimums, the enhanced mandatory minimums, where it has the risk of going the other way. That's not to suggest that there may be things that need to be adjusted after this, but I will say that I've not been a proponent in a pilot program in this area because the length of time in which it will take to get meaningful reform after the pilot program may be past the point in which the budget issue would overtake us, and that we would see ourselves like states such as California that simply had to say, okay, now we don't have an ability to make some meaningful reform, and it will have to be just a release regardless of risk of recidivism. I'm probably more scared of that than I am scared of what the impact of these modest reforms may be. Judge?
Also, this history of pilot program is such that regardless of the outcome of any pilot program, you then get a debate about whether a particular sample within the pilot is representative of the remainder, and it will be years in resolving that. As I think it's better sometimes it's a little bit see across the board what's going on.
Just briefly, if you're, the way this is designed to happen is, of course, in an individual case basis for these releases or sentence relief that would be imposed under provisions of the Act. And you have in a way already a pilot program or template out there in the way that the courts handle adjustments to the sentencing guidelines and situations in which individuals become eligible for resentencing or at least consideration of resentencing based on those changes in the guidelines. And you'll see that is the rare case in which the individuals applying for that kind of relief actually are granted a reduction in their sentence. So there's a very structured process with a lot of judicial oversight, much akin to what we anticipate will happen with this statute. As a result, you're not going to see this sudden. Well, we have a model for how it will work, and this is going to result in a sudden influx of people to the community.
Thank you. Yes.
I'll go ahead and just follow up on the question of numbers. How many people, if we're talking about reducing the number of folks in prison, if we're talking about affecting lives in some meaningful way, how many folks do you think would be touched then by the laws currently proposed? I think you're just suggesting some, folks aren't just going to be released en masse. Well, how many folks then, how many people in the criminal justice system would potentially be impacted by the laws as it's proposed?
So there's been, a lot of discussion about that, and the worst case scenario that some might paint would be that 11 to 15,000 people, and I just don't think that anything that we've heard from the panel would suggest that this is going to be everybody's got to go. And the statute doesn't provide that, so the number was going to have to be smaller than what the biggest part would be. And I'm very sensitive.
That would be if every judge and every prosecutor said, yeah, okay.
And I got to agree with the judge, being an academic, we argue about sample size, all day long, those kind of things. But what really happens is that each person has to make their own case. And if they survive that case in a way that gets them earlier released, then what was bad about that? Right? There's a lot of good eyes looking at it. And the modest reforms matter. One of the things that I know this bill does that I found very encouraging when I read it as one individual, not so much the chairman of the group, is that there's a lot of direction on the Bureau of Prisons and Probation, Parole, and Justice Department to take really hard, empirically based looks at recidivism, high, low, moderate. Take a hard look at what people are doing in prison to change their lives. Not being a corrections official, I know enough about corrections to take this. If people don't have any hope of that they get better in prison, it's not much of an incentive for them to do good things. And if you're, a 30-year-old person, like in the case they spoke of, who's looking at 55 years in prison, what's really their motivation? So why would we just not give them an opportunity to take advantage of what may be is actually better treatment, rehabilitation, and reduce recidivism strategies?
My inexact, unofficial, just Brett Tolman's bad math. Remember, I didn't major in math either. I think you're talking about a 2%, possibly give or take, but you have over 230,000 individuals in the system, and you have, I believe, after all of this, and you have judges and you have prosecutors, that you may have 3,000 to 6,000. Yes.
I have a comment and a question. My comment is that, this bill notwithstanding, the issue of social services is still there. And so what I mean by that is, what we're doing now is just incarcerating people who need social services. So regardless of whether this bill is there, that's not really an issue that we need to, that it needs to address, because that issue is always going to be there. Because part of the reason we're incarcerating is because we're not having adequate mental health services, adequate drug addiction services. My question relates to, I'm noticing through the conversation, there's bill focus on non-violent drug offenses. However, I want to point out that the states are really taking the initiative, as you stated, in terms of reducing incarceration. However, the state prison population is mostly violent offenders, and they're still managing to not just nonviolent drug offenders, because there's good research to show that, you know, individualized risk assessments are ways of protecting the community and protecting public safety while also being able to reduce the prison population and also reduce the.
So I may need you to clarify the question.
I guess,
For me,
well, I guess perhaps, is there room to expand this conversation beyond just focusing on nonviolent?
it's an interesting question because there's schools of thought that say that drug offenders are classified in the violent, and that's an oxymoron that the judge has expressed because, and I can say my personal experience, drugs fueled all the violence that I did see as a prosecutor. But that wasn't to suggest that when an individual had even just a modicum of rehabilitative services, that their thinking did change drastically. And so you see that there may be the most room for what you are articulating, and is the great need for dedicated resources to rehabilitation. I'll turn it over to the panel, but this last I'll say that many prosecutors forget that there are 3 prongs to the mandate they receive. Yes, it is to punish and it is to deter, but the 3rd prong is rehabilitation. But they don't want to talk about that. That's not what you focus on day in, day out. Changing the discussion, emphasizing that's a message, proper message to Congress, that those services are important. And I think the chiefs of police will tell you, and my father told me, he cared about the people that he arrested, and he often hoped that there was progress and improvement, or that there was abilities and resources for them, because he knew that he was going to see them again, and he wanted them to have success. There wasn't animosity there. Those are just my thoughts on the question. All right. Any other questions? Let me thank the panel and for each of you for your participation, for the thoughtful discussions. I'm certainly going to try to make myself available, and I know the panelists have made themselves available by through email and phone calls and discussions, and I've appreciated interacting with them. So.